So anyhow, we'll get started. Judge Advocate is Curtis McNeil, the Assistant Department Judge Advocate. Please be not Because this is a training session, we are going to have a little bit of academic leeway, license here in this process. So if you got the script, that script is handy, and if it's your first trial, follow it closely. If you're your 15th or 20th trial, you know where you can cut things down. I'm going to jump over some things here and there, kind of condense things, try and get us through this so we're not here all day. I've been in 3-hour trials. I don't recommend them. But as we go through some things, there are going to be some objections. We're going to say, yes, that is true, but then we're going to proceed ahead anyway. That is so that you actually get the benefit of what we're trying to do and we don't just stop and leave. Once we're done with the trial, hopefully we'll have a few minutes for some questions. If you've got questions that have nothing to do with the trial, we can do those too, either today, during this, after this, in the hallways. Find Dave and I. We're here for you. Our whole job is to make your life easier and help you answer questions. So if you've got a question, don't hold on to it. Don't think it's a dumb question. The only dumb question is the one you didn't ask and then left without the answer. Clear? All right. Before I start any trial, you'll hear at one point I asked about voting. And voting can be done one of two ways. It can be voice votes, or you can have actual voting slips for the jurors. That's you. In a trial with more than about 7 jurors, it is unmanageable to do it on paper. It really is. So I highly recommend, you highly recommend to your jurors that we do it by voice vote, because the only time the specific number counts, or it's either more or less. The majority rules on everything except sentencing, and that is if the sentence is to expel somebody from the Legion, it has to be 60%. So the one time you have to count carefully is easier than trying to read 30 or 40 ballots and have somebody go away for half an hour and count ballots between every charge, every specification, every sentence. They'll be there all night counting and not get the thing done. So you'll see that part as we go. I highlight that. Other thing I want to highlight is, at the judge, if you're the judge, you have a report of results of trial pre-done. I have one I do beforehand that lays out the charges and says guilty, not guilty, circle 1, and has the charges and all the specifications so that as I'm going through, I can see what I'm doing and I have it. And the other nice thing is when the trial's over, it takes me 5 minutes to finish up and sign the report of results of trial, and I can hand it to the post as I walk out, and it can be part of the post package. We don't have to pass it back and forth and everything else, along with the trial transcript, the sentencing, the charge sheet, all of that. It all goes in one packet to the department. Save yourselves a huge headache. Have that filled out in advance so that it's just circle here, slash there. You're in and out in 5 minutes at the end. It takes you half an hour before you get there. Huge advantage, highly recommended. With that in place, I've got the prosecution over here, I've got the defense over here, witnesses are going to be in that chair, and we'll swear them all in as we go. I will start. All right, this court will come to order. This court is directed, is convened at the direction of the commander of post ABC, in the letter, copies of which have been provided to the judge, counsel, accused, and the recorder for this. Is there any objection to the convening order or any errors noted on the face of the convening order? Prosecutor, defense? Mr. Prosecutor, are you prepared to proceed in the trial in the case of American Legion Post ABC against Legionnaire Billy Butthead,
yes,
a member of Post ABC who is present here in court?
Yes, I am, Your Honor.
Prosecutor, who's been assigned to record the proceedings? Who's your recorder?
I don't have one.
Okay. First academic point. we have to have a recorder, somebody who's going to record the proceedings. You can either do it on a tape recorder and then transcribe it later, or have somebody take notes. But we need to have somebody who makes the official record of what happened at the trial. In this case, it's going to be Mr. I don't know. All right.
You need to keep a copy of that recording, if you're going to transcribe.
Once it's been transcribed and approved by the judge, it no longer needs to be retained. But it doesn't hurt anything to keep it around. I wouldn't delete it unless you ran out of space or anything. But once you have an official transcript that has been approved by the judge, the recording is no longer required.
Yeah, but here in the transcript, Bob Butthead versus Billy Badass. Who's on trial?
Billy Badass is on trial. My error. Thank you. Okay. I'm not going to swear in the recorder because we don't have one right now.
We can get one.
We're fine. I would normally swear in the recorder, say, are you going to do your job properly? You know, that whole thing. Faithfully perform the duties of recorder. They say yes, we're good. Prosecutor, have you acted as an investigating officer, judge, court member, judge advocate, or a member of the defense in this case, or as counsel for the accused in any proceedings on these matters?
I have.
All right.
The witness is over here.
All right, we're good. At this point in trial, it is appropriate that I advise you as the defendant of your rights in regard to counsel. I'm sure you've been previously told of your right to counsel, but I want to satisfy myself that you understand. You have the right to hire an attorney to represent you. You have the right to have a member of the American Legion represent you. You have the right to both have both assistant representing you, and you may appear without representation by yourself. Do you wish to proceed without counsel, or do you have counsel present?
Let's proceed. I'm not scared.
All right.
Be afraid. Be very afraid. You don't want that. Just be the one, not be the one like that.
Does the Legion post or the defendant wish to challenge the judge for cause? Prosecution.
How do you know? How late were you up last night?
About 9.
Okay, you're good.
All right, the accused is now going to be arraigned. The accused, counsel, recorder, and the judge have each been furnished with a copy of the charges. Does the accused desire that the charges be read?
I'd like to know what they are, sir.
All right, Mr. Prosecution, please read the charges. So people be reading.
Okay, post ABC versus Billy Badass. And this is from Sally Busybody. Being a member of the American Legion and post ABC, bring the following charges against Billy Badass and state. Conduct unbecoming a member of the American Legion. Number 1, Billy Badass did on June 8, 2024 at post ABC located at 1 Justice Drive, Integrity, Florida, exhibited conduct behavior that was unbecoming of a member of the American Legion by committing a battery on Bob Butthead by pushing and or shoving Bob Butthead against the wall and without his consent. B, the push or shove caused Bob Butthead to fall on the ground. C, the incident took place approximately 6 p.m. at the post-social quarters while dinner was being served. Such behavior is conduct unbecoming of a member of the American Legion. Signed, Sally Busybody.
Mr. Prosecutor, are those charges in the proper form?
No, we have to say no.
All right,
And
here's
I'll tell you why.
Yeah, please do.
Because it's not notarized. That's why, at least mine's not. So I can't assume that it is notarized.
Okay, so a couple of things. The charges have to be signed by a member of the American Legion?
It's fine, but it's not her.
Is Sally a member of the American Legion?
No. She is an auxiliary member.
Oops! Problem number one for academic purposes. Okay, properly sworn to before a notary public, you said no. So we've got two problems. And do we have a referral of the charges to the court by the post commander?
No. No.
So we're 0 for 3. If this was a regular trial, we would be not convening this trial. We would have to have the charges resubmitted by a member of the post, sworn before a notary public, and referred to trial by the post commander. The good news is the charge was conduct unbecoming, which is an authorized charge. Yes, you have a question in the back.
What if it's the post commander on trial?
It's going to be whoever is next lower in ranks.
So the first vice then, I'm assuming?
Yeah. Normally the charge is going to be referred, it's going to be paperwork through the adjutant.
Yeah, the adjutant actually does the paperwork. The post commander is just the one who signs it. In your case, if it was the post commander, it would be the first vice who would be signing, referring to trial.
Thank you, sir.
I'm going to get this wrong. Mr. Badass, how do you plead to that charge?
Not guilty. He was Navy.
Your wife is maybe.
We have a question in the back, yes.
No, you have visitor, sir.
Okay, this trial is going to recess briefly for our visitors.
Come on
We're in
up,
recess.
Mr. Ramos. I think everybody knows NEC Jim Ramos. He has an honor guest with him who he's going to introduce.
Thank you for being here. Thank you for, I know you needed that recess, that's why I came in. You all know we have somebody from Kansas. He loves our weather down here. He says it is summer almost for him. Our next leading candidate and our next national commander, 25 to 26, Dan Wilder. Good morning.
Good morning.
It is great to be here. First off, I see all the red, rocking the red. You guys are doing an awesome job. It was pretty warm out this morning. I'm sure you thought so too, right? You know, I smile and laugh when I look at this. For those of you that don't know me, what I do for a living is I'm a district court judge. And so I know a little bit about recess. No, I don't want to do that. I've been a district court judge since 2009. Before that, I was a municipal court judge since 1997. So I've been doing it a few years. I was actually our Kansas Department Judge Advocate from 2005 until 2009. I actually had to step down when I got appointed by the governor as a state district court judge. So it's awesome to see so many people in here. And I'll tell you the importance of making sure your post, district, department, whatever it is following your constitution and bylaws. Because I tell people this all the time in court. And I do a lot of domestic court. Yeah, fun stuff, right? Yeah. And sometimes parents don't want to do what the order says. They do their own thing. And I say, we can't do that. And they go, why can't I? You know, I'm making my own decision. I said, because if you don't follow the law, and I have people just do whatever the heck they want to do, what do you got? You got chaos. You don't have anything, right? And so it's important to make sure the rules are followed and people aren't doing just what they want to do, but are doing what the Constitution and bylaws says you can do. Otherwise, you just have chaos. You just have people making up their own rules and doing whatever it is they want to do. All right? So I appreciate your training here this morning. I would encourage you to look at your post-Constitution and bylaws, make sure they conform with your district, your department, and your national, make sure they don't conflict. That's important. but also just make sure that you and your membership is familiar with your constitutional bylaws. Make that available. It's not a secret. That should be posted in your post somewhere. It should be available to all your members. And just make sure that your post is following your constitutional bylaws. It's the easiest way to keep you out of trouble. And by the way, not following your constitutional bylaws is the easiest way to get your rear end sued, right? So with that, I just say thank you for everything you do. God bless you, and God bless the American Legion. Thank you.
Don't go to Kansas, buddy.
All right, we've had the arraignment, we've had the plea of not guilty, so now we're going to proceed to trial, and this court will come to order. This court is convened by the direction of the commander of Post ABC. Copies of the letter have been provided to the judge, each member of the panel, counsel, and the accused, and to the recorder for this insertion into this record. The charge has been properly referred to this court by trial, and we have Legionnaire, I don't know who's been assigned to record. I am Curtis McNeil, the judge advocate at Post 356, and I have been detailed to preside over this trial by the commander of the Department of Florida. Will the prosecutor please introduce yourself to the jury panel?
I don't know anybody, Rick Post 57.
And defense, you have no counsel to introduce. Is the prosecution ready to proceed with the trial in the case of American Legion Post ABC against Legionnaire Billy Badass, a member of Post ABC who is present in this court?
Yes, Billy Badass is here. Oh, there he is.
Are you ready to proceed?
Yes, I am.
I'm Billy Badass.
Oh, my bad.
Butthead.
He's the butthead, he's bad.
All right, the jury will now be sworn. All jurors, please stand. That's all of you. Do you state your name, swear that you will faithfully perform all the duties incumbent upon you as a member of this court, that you will faithfully and impartially try according to the evidence, your conscience, and rules applicable to trials in the American Legion in the case of the accused now before this court, and that you will not disclose or discover the vote or opinion of any particular member of the court upon findings and sentence unless required to do so in the course of the law, so help you God.
I do.
All right, you may be seated. This court is now assembled. Does the prosecution or defense intend to call any member of the jury panel as a witness?
Yes. No.
Yes. Which ones are they?
Yes, no. Oh.
Who
I guess we have,
are our witnesses?
we have, Karen Badass. We got, Susie Barton, busybody, oh, no, Barton, my bad. And, oh, and Bob Butt had the victim,
All right.
the accuser.
In the event that this was not an academic session, I would take them out and sequester them outside the room so that they couldn't hear the testimony of each other. The defendant gets to stay because he gets to hear everything because he's the defendant. But we're not going to do that because, again, it's a training session. Members of this court, the accused has an absolute right to be tried before a panel of impartial court members. Therefore, it is mandatory that you disclose any and all reasons that may exist that would keep you from being fair and impartial to both sides. The following reasons are proper grounds for challenge. The member is not eligible to serve on the jury in the American Legion trial due to a lapse in membership for non-payment of dues. You're not a member of this post. You're the accuser, a witness for the prosecution, a witness for the defense. You're the investigating officer, a judge, advocate for the post, a convening authority, or have served as counsel for either side, or that you have formed or expressed a positive or definite opinion as to the guilt or innocence of the accused, or any other reason which would cause substantial doubt about the legality, fairness, or impartiality of this trial. This any member know the accused or counsel for either side? Come on, you're members of the same post, somebody
Yes.
does it. Somebody know the guy.
Yes.
For academic purposes, all right, you know him. Does your knowledge of the member give you any reason to think that you would not be able to fairly and impartially hear this trial? No, it does not. Does the prosecution or defense wish to challenge this member of the jury?
No.
Nope. Prosecution? Sure. Does any member of the jury employ any other member of the jury?
No.
Perfect. If that was the case, we would again question to determine whether that's going to influence their ability to try this trial. Is any member of the jury aware of any facts or circumstances which would prevent you from devoting your full time and attention to this trial? Does any member of the jury have information concerning the facts or circumstances of this case that would render you unable to render a judgment in this case? Having heard none, we will proceed. The charges are, we've already read them, I'm going to skip over reading them again. Will each member agree to follow the laws given to you by me?
Yes.
Affirmative response from all members. Has any member of the jury heard any details of the case from the news media?
No.
Negative response from all members. Is any member aware of any other matter which you believe would be grounds for challenge by either side against you?
No.
Negative response from all members. Mr. Prosecutor, do you have any questions for the jury?
No.
Defense, do you have questions for the members of the jury? Does the prosecution or defense wish to challenge any member for cause? Yes. All right, we got negative response from prosecution and defense. We got a question in the back.
I have a question. Back to the question about does anybody employ any of the members of the jury? Would Susie Bartender be an employee of the post? And would that count?
Susie Bartender's a witness, she is not on the jury.
Oh, gotcha. Okay, thank you.
If you are a witness, you are not going to sit on the jury.
What about people who are officers and opposed? I mean, are they considered employees if you like the sector or third class?
No. What we're looking for is if your livelihood depends on somebody else on the jury in order to eat and pay your rent or pay your mortgage or whatever, that might influence your vote. And so we're trying to see if they, and the question we're going to, all I'm going to do with that is say, are you able to independently make your own judgment despite the fact that this person pays your paycheck? And if they say, yes, I am, and are you not going to hold them responsible for their vote in their regular business? If not, cool, we can proceed. If it's going to be a problem, we kick one of them out because we don't want the jury to be tainted by that issue.
I guess what about trials where it's obvious that the entire post already knows what's going on, and it comes to a trial, there's not a single person in the jury that can say they don't have knowledge of the trial.
Right, and so we find out what knowledge they have and whether they can set aside their previous understanding of what happened and listen only to the testimony. So we just question them to make sure, and if they say, no, I've got, my mind is made up, good, and you can make up your mind out there if you're not staying for the trial. That's all you're trying to do is make sure that everyone can fairly and impartially judge the material that comes up and not have pre-set positions that they are unable to set aside if evidence comes forward that would change their mind. Sir?
All right, so you put this stuff on the bulletin board for 30 days according to the rules of trial.
Right.
You're telling everybody what the...
Right, they know what they're gonna know what the charges are, and they're gonna hear about it, but the question is, have they made up their mind that something as to what happened and are unable to listen to the evidence?
Yeah, so then you go into the courtroom or the hall or wherever, and you've got to interview every one of the witnesses, every one of the jurors to make sure that they know.
Either every one of them, or you ask a general question and get, is there any, Are any of you unable to set aside your prior knowledge of this case?
can
And
do
they
it
raise
now.
their hand, and then I question them.
All right.
Yeah.
And what, and it'd be your determination as the judge, whoever the judge is, whether to let him stay or not?
Correct. The judge makes that determination. The prosecution and defense can also ask questions, and then the judge makes a determination based on that. If they say, no, that's fine, we're good, then there's no problem. If they want to debate about a particular juror, with as many jurors as we have, I'm going to err on the side of caution, and that juror's just going to sit it out. There's no point in creating an appellate issue when you've got 30 jurors. That one just doesn't get to play.
So, I'm understanding now, so what you're saying is that, that you can ask a jury that, if anybody has any knowledge or has an opinion about the case, then you would dismiss them?
If they have an opinion that they could not be swayed by the evidence presented and are not able to set aside their opinion and listen to the evidence. So if they, if the guy said, "Oh, I heard that Bob shot Billy," okay, the fact that you heard that is concerning, but that rumor that you heard, are you able to set that aside and listen only to the evidence that should be presented today and fairly and impartially try the trial? And if they say, "No, I'm convinced Bob shot Billy," you're out.
Besides hearsay, if you're talking to the individual, then that's automatic.
Well, it could be, or, if they could be a witness at that point. They might go from a juror to a witness at that point.
Thank you.
If they also had any kind of bias for the individual, regardless
Right.
of the facts of the trial, they're going to have an act of crime.
Yeah, if you've got an axe to grind, yeah, we're not wanting you here.
I want to complicate this just a little bit.
No.
I'm going to bring technology into this. So some of the evidence of characteristics fall into a Facebook post, and some of the jurors are like it, and they like it, and you have a copy of it. What does that do?
Well, that would be up to the prosecution or defense to bring to the attention of the judge. And then the judge would then ask those people about, okay, did you like the post just because you like everything on the American Legion Post ABC posts? Or was there a particular reason you like that? And does your having read that post render you unable to listen to the evidence? Same thing.
So if it's the person on trial, and it's a friendship, and you liked it under the person's that's on trial.
I'm friends with a lot of people that I end up on trial with. The fact that you're friends doesn't mean you can't fairly and impartially judge the evidence presented. But I would definitely ask the question, if you guys were best buddies, go fishing every Friday, play golf every Thursday, are you going to be able to fairly and impartially hear the evidence and make a determination? And I'm going to be pretty skeptical about that. And if the defense or the prosecution says, you know what, I want to challenge that person for cause because of it, I'm probably going to sustain that. But that's a challenge for cause by the prosecution or defense. Sua sponte, as the judge on my own, I'm not likely to boot somebody if they answer my questions the way I expect them to answer. But if their answers result in either the prosecution or defense feeling like that person can't impartially hear the case, it's up to them to then say, I'd like to challenge that member for cause. Because that member, those guys are best fishing and golfing buddies. There's no way they're going to vote against that other member, regardless of what the evidence shows. And at that point, it's probably going to be sustained and that person's going to sit out.
Here comes a good twist. What happens if you have the trial set, the jurors are all there, prosecution is there, and the defendants do not show?
Then you do a trial in absentia. We've done that. I've presided over one where we did that.
So did I.
We've had the trial set. We've gone through. We've even had several continuances. So it's not like the defendant didn't know how to do a continuance because we're on our fourth one. And they put up a Facebook post that said they didn't feel like showing up and they weren't going to be there. And somebody brought that to my attention as the judge, and I said, okay, well, we'll wait because they still have the right to show up. And we looked for anything. They can put in a written submission. There was no written submission. There was nothing there. And we said, well, we're proceeding in absentia. It's a much shorter trial that way. But we still had to go through all the trial procedures. We went through all of the charges and specifications. We went through all the voting, we did everything by the book, so that if a person decided to appeal, and they have a right to appeal even if they didn't show up, that appeal had no basis because they had failed to exhaust their remedies, for starters. They had the opportunity and failed to attend. Now, if there was something wrong with the trial, like our charge sheet here, they could appeal and win, because our charge sheet wasn't by the right people, wasn't notarized, all of that. That's an easy appeal. So they can still appeal, so you want to go through and be as solid as you can on the trial without the member there. It does make it a fast trial, though. All right, members, one more, and then we're going to proceed.
Since the original indictment was insufficient for the 3 reasons already submitted to the court, and since the jury has already been sworn, which places the defendant in jeopardy, therefore a motion to dismiss would be in order, and the defendant can never try again on the same charges.
Potentially.
He's hired.
Depending on the facts and circumstances and when you found it, yeah, if we'd already sworn the jury, we'd be out of luck. But prior to swearing the jury, he brought that up. We hadn't sworn the jury yet. In that case, they would hopefully withdrawn the charges and tried again. But yeah, if we get all the way to here, we could actually get a motion to dismiss and we've already put the person in jeopardy and they get to walk.
That's why I waited for the jury to be sworn.
But for academic purposes, we're going to assume that they were properly sworn in front of a notary by a member of the post and referred to trial by the, we left those things out so that we could do a train on those very things. But yeah, we're going to presume everything was done properly to move forward, which you're absolutely correct. All right, so before we proceed into the presentation of the case, and this does have to be done before you proceed into presentation of the case, members of the jury, we have 2 options for how we vote. Voting on guilt or innocence and on any potential sentence can be done either by paper ballot or by a voice vote. Because of the number of people here, I recommend to you that we have the votes by voice vote. However, that is not my decision, that is yours.
I make the motion that we do the vote by voice.
Second.
All those in favor?
Aye.
All opposed?
No. Hey.
Okay, hands for those in favor. Hands for those opposed. The ayes have it. Votes will be done by voice vote.
Question?
Guilty.
It would be more accurate instead of a voice vote to have a counted hand vote. Because by voice vote, whoever yells the loudest, that side wins, and that's not justice.
All right, defense counsel, your point is taken. We will do by hand vote with counting. Thank you. And you're right, that's why you saw me go to hands the minute I didn't have straight eyes. And that's why. If everybody voted the same and I didn't get any nays, I would have just gone with it. But yeah, the minute I had 1 nay in that audience, I immediately reverted to a hand vote so that I could make sure that my majority was a true majority. I do that out of habit. Thank you for bringing it up so that we make the academic point. All right, Mr. Prosecutor, do you have an opening statement?
I do. No, I do not.
All right, no opening statement. Do you have a witness? Would you like to call your first witness, please?
I guess my first witness will be the accused. I can't give you. All right, then I guess I gotta go with Karen Badass.
Ms. Badass, if you could approach.
Badass, get a, whatever.
Could you face us so we can hear you back here in the back 40?
I'm calling Karen Badass up. If I can answer any question.
Ms. Badass, please stand in front of the chair, raise your right hand. Turn that way. Jury, please raise your right hand. Do you swear the testimony you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Please take your seat. Prosecutor, you may proceed.
Good morning, Ms. Badass.
Good morning.
How you doing?
Good.
Okay, before you start asking questions, the first thing the prosecutor needs to do is have the witness state their full name, post number for the record.
So for the record, can you give us your first name, complete name, and your post?
Karen Badass, post ABC.
Thank you. So does he swear in before you ask her name, or?
Yeah, you're swearing in before she sits down.
Does she have to be in good standing?
She does have to be a member in good standing, yes.
Question,
That's why we ask what post she's a member of.
if she's the defendant's wife, she cannot be a witness.
According to what?
According to what?
By law.
What law?
Unless she chooses to.
If I was in a Florida courtroom, she could have spousal immunity, you're correct. We're not in a Florida courtroom, we're in an administrative hearing, and as such, she can be called as a fact witness.
It'll still be run for you.
It would be.
You're married in church, it still counts.
Where's Sam?
All right.
He's back there.
Sam, you heard that, Sam? All right, we're going. So, Ms. Badass, I understand that you were at the post on June 8th, 2024 with your husband.
I was.
You know, having drinks and dinner.
Yes, sir.
And can you tell me exactly what happened that Mr. Bob Butthead did that caused this?
All I remember is he stumbled. He got up from the bar and he stumbled into our table and I spilled my glass of wine. Of course, some of it went on Bob.
So do you think he was intoxicated?
Sound off, we can't hear you.
You believe he was intoxicated? Yeah.
Absolutely.
She says absolutely. So what happened after he stumbled? What did your husband do?
He defended my honor, of course.
By?
He confronted Bob Butthead.
Well, you just said he defended your honor.
He did.
By? How did he do it?
He confronted Bob Butthead. He stood up and confronted Bob Butthead.
And what did he do when he confronted Bob Butthead?
Bob Butthead slipped and fell down on the ground.
So he didn't jump in or put him down?
No,
Do it.
absolutely.
Were you drinking?
No.
Oh, okay.
She just
Sounds like
chewed
Bob
on.
Cover yourself.
No other questions for this witness, Your Honor. Thank you.
Sorry.
Defense, do you have questions for this witness?
I think you did a fine job.
You can be represented by another member of the league.
Your Honor, may it please the court. For the defendant, was the accused possibly provoked into the action that he was caused to defend your honor?
Absolutely. He had just bought me a glass of wine and Bob Butthead spilled it.
Didn't even get a chance to drink.
So
You
you
haven't
think
drank.
that possibly the accused was justified in his actions?
He didn't do anything wrong.
So he had no choice but the actions that were provoked to him in order to...
Objection.
Guys ran away.
Pause for stipulations. Speculation.
In your opinion, was he provoked into his actions?
My husband didn't do any wrongdoing.
Thank you, Your Honor. Any further questions?
Prosecutor, my next
Said that
witness.
is true.
I'd like to challenge Karen Badass for cause.
As what?
She's married to Mr. Bush.
You called her as a witness.
All right, then I guess we'll have to... No, when next witness, Your Honor, will be Miss Sally, was it Sally Busybody? Susie Busybody, please.
Susie Bartender.
Oh, bartender, I'm sorry, bartender. Susie Bartender. I got you, I got you.
My name. Good song.
You swear the testimony you're about to give is the truth, the whole truth, so nothing but the truth, so help you God?
I do.
Please state your seat. Give her name and whether she's.
Can I get your full name and are you a member of the post?
Susie Bartender, I am a member of Post ABC.
Thank you. First question, Ms. Bartender. What time did you start your shift?
4 p.m.
4 p.m.?
Prosecutor, can you please speak up?
Oh,
Okay.
I asked her what time she started her shift. I'm sorry. She says she came in at 4 p.m. So was Bob already drunk, or do you think he was already impaired when you got there?
I don't believe so, no.
She doesn't think he was impaired when he got there. When
Okay,
she got-
just for another academic night, all of our bartenders have probably been to training and should have been to training as to ability to recognize whether somebody's been overserved, and it's called the Safe Serve program here in Florida. So that would be a question, especially if you're talking to a bartender about whether somebody's intoxicated, to set the foundation for how they would know. And part of it is, I've been trained to recognize people who are intoxicated and cut them off when they reach a certain point. And that way, when her opinion comes forward as to whether or not somebody's drunk, you've got a basis for it.
Fair.
Go ahead, I'm sorry.
Now you have to hear me right. Okay, so, Ms. Bartender, was Mr. Butthead already drinking Bud Light when you got there?
He was drinking a beer when I came on shift, correct?
He was. But you don't know if he had anything before that because you weren't there, correct?
That's correct.
So can you tell me in your words exactly what happened?
I came on shift at 4, served Bob Butthead. He was leaving his stool around 6 p.m. I was doing my due diligence with other patrons. Heard a commotion around 6 p.m. as Bob Butthead was leaving. I saw there was a problem at the table with the Commander Badass and his wife. Heard a commotion, looked up, and Commander Badass shoved Bob Butthead to the ground, and other Legionnaires helped Bob Butthead to his car.
Oh, so you did see the commander shove Mr. Butthead?
Yes.
Huh. Okay, I have no other questions for you. I do have one more. Has anybody else besides yourself seen the incident? Have seen the incident?
As bartender, I'm in charge on duty, so I didn't ask any other patrons at the time.
Okay, thank you.
Defense counsel, any questions for this witness?
He's the bartender.
Use the microphone.
It's actually a good idea.
Ms. Bartender, did you have direct line of sight to observe the shoving incident prior to the shove?
No. I heard a commotion, I looked up at the table and saw the incident.
So you had no way of knowing if the accused was possibly provoked into the shove?
That's correct.
I have no further questions.
Prosecution, any more witnesses?
No.
Defense counsel, do you, you're excused, please.
You have-
Defense counsel, do you have any witnesses?
Oh, well, wait,
you don't-
I do have one more. I'm sorry. Can't remember his name.
Bob Butthead.
I'd like to call Mr. Butthead.
Do you swear the testimony you're going to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Please state your seat.
Good afternoon, Mr. Butthead.
Good afternoon, sir.
So can you tell us, the court, exactly what happened to you at that night?
Yes. I'm a member of Post ABC, and I injured my leg while I was on active duty. I can walk with assisted crutches or a walker, but I usually use my wheelchair. I arrived at Post ABC on June 8, 2024, and drank Shirley Temples most of the day. Until other people at the bar started teasing me about it, so I started drinking Sam Adams. I got up to leave about 6 p.m. and started walking to the door on my crutches. I lost my balance and accidentally bumped into a table where this broad was sitting. And I apologized to her and started for the door. This mean old broad accused me of being drunk. She said I drink too much and that I should watch where I'm going. I told her I might be drunk, but she was ugly. I'll be sober tomorrow, and she'll still be ugly. She then threw her drink on me. I started to turn back around to leave when I was shoved to the ground by Commander Badass.
Okay, well, thank you for that. I guess it's on them. I have no other questions for you, sir.
Defense counsel, you have any questions for this witness?
Yes, Your Honor. Mr. Venice, you just admitted to the court that you were drunk. Is
No,
that
sir.
correct?
No, sir.
Butthead, not badass.
Oh, Butthead.
I'm Mr. Butthead.
You're Mr. Butthead. But even refreshing your memory, looking at your script, you did admit to the court that you were drunk.
No, sir.
For the recorder, can you read back that testimony?
Can I read it?
Yes.
It says that I might be drunk. It doesn't say I am drunk. It says I might be drunk. Did that admit it?
Yeah.
Could be.
Okay.
She's ugly. And we'll be that way tomorrow.
Okay. In your opinion, would it be reasonable to infer to the reasonable person that your comments made to the accused wife would be against her character?
Objection.
No.
Speculation and opinion.
Sustained rephrase. In the words that you spoke to the accused wife, were they proper words?
Ugly is ugly. You can't fix ugly.
Hostile.
So in the actions concerning your possible intoxication and the bumping into the accused wife and spilling the drink and the accused taking action to defend his wife, those actions were taken all in conjunction of what happened that evening in your canteen, correct?
Repeat the question, please.
Your statement that you possibly were intoxicated and that you bumped into the accused wife, spilling her drink, and the words mentioned to the accused wife were against her character, then that led to the defendant taking his action against you, which resulted in a shove.
So you made he shove?
Objection. Speculation.
I'll rephrase. When the accused shoved you, that was as a result of something that happened before, correct?
Yes.
The bumping into the accused wife and spilling the drink had no implication on the shove?
Maybe in his mind, but I just did it by accident.
Okay, so your accident on bumping into the accused wife which resulted in the spilling of the drink, which resulted in the accused taking his action, that all could have been an accident, correct? Why would it not be an accident?
You're leading the witness.
Because he did it purposely.
He's allowed.
He's allowed to lead the
Accidentally
witness
show
because he's
somebody.
cross-examining the prosecution witnesses.
You don't actually accidentally shove somebody, you intentionally shove somebody.
Speak up.
Say that statement again.
Read my statement.
Say that statement again.
No, say that statement again.
Loud.
Okay, you cannot accidentally shove somebody, you intentionally shove somebody. You accidentally bump into somebody, you don't shove them.
Okay, so the witness just stated that a bump can be accidental, but a shove cannot be accidental. So,
Correct.
okay. So again, that's your opinion, and the accused can have his own opinion that his actions were justified. I have no further questions.
Please don't act, Your Honor.
Proceed.
So, Mr. Butthead,
Yes, sir.
so Mr. Billy Badass had to get up from the table to shove you, correct?
Yes, sir.
That's all, Your Honor.
Any recross of this witness?
No recross, Your Honor.
Prosecution, any further witnesses?
No, I have none, Your Honor.
You're excused.
Thank you.
Defense counsel, do you have an opening statement? Very brief, we're running low on time.
Very brief.
The defense wishes to show the members of the jury that the incident that happened in the canteen of Post ABC was accidental and was caused initially by the actions of the accused. And at this time, the defense wishes to call its first witness, Mr. Billy Buthead.
Mr. Badass, raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God. Sure. Yeah. All right. For academic purposes, if he was not represented by counsel, I would have to explain to him that, you know, his testimony could be used against him, all of that. But since he's got counsel, that's up to his counsel to tell him.
Mr. Badass, will you explain to the jury what had happened that the night in question in the canteen of Post ABC?
It would be a pleasure. My wife and I were enjoying a glass of wine, just sitting at our table, and believe me, the tables were spread out, so there was plenty of room between the tables, and all of a sudden, this drunk came over and fell on top of my wife, on top of her. I got up and pushed him off. That's all I did. He's lucky I didn't clock him.
He's a disabled veteran.
I don't do things like that.
Okay, now you're Badass. So you felt that it was an action in defense of your wife, correct?
Yes, he called my wife ugly, and he was laying all on top of her. I mean, what would you do?
And also, in your opinion, he appeared to be drunk?
He was hammered. Are you kidding me? He's drinking Sam Adams. It's like 90% alcohol. He's smoking them big-ass cigars.
Was he smoking the cigars inside the post?
Yes, he was.
Is that against your post regulations?
Yes, it is. But he's old and we don't pick on him.
Whoa. Also, in your opinion, you believe that the person that accused you was intoxicated to the extent that he should have been cut off by the bartender?
We were very very busy that night, and I can understand if the bartender wasn't counting the number of beers that he had. But, yes, he should have been cut off, and maybe that was partly my fault. Let her know that he was getting out of control. I mean, he got his wheelchair taken away from him.
The person who is accusing you operated a motor vehicle on his way to the post and also used that same motor vehicle to drive out of the post?
I believe he did drive, but I don't, they were holding me back there, so I wasn't allowed to follow.
Objection, that's irrelevant.
Sustained.
I have no further questions, Your Honor.
Mr. Penn, you're excused.
Thank you.
Mr. Penn has any other, oh, wait, I'm seeing cross-examination. Prosecution, do you have any questions?
I sure do.
Speed this thing up.
So, Mr. Badass, you heard the testimony from the bartender, and she said she saw you shove him. Not that he was laying on top of your wife and spilled the drink. That's not what she's saying. So you're saying the bartender's not telling the truth?
If it pleases the court, if you want to sit in this chair, I'll show you what I did.
Oh. I think maybe Mr. Badass, or Mr. Butthead might, but I don't.
He was laying all over the top of my wife. He had lost his balance.
So your wife never threw the drink at him after he called her ugly?
It was kind of it happened in kind of like, as he fell, her drink went flying.
Okay.
Right, honey?
Alrighty. So, I guess you must be innocent then. No other questions, Your Honor.
All right.
Wait, maybe let me do something.
They got defense team?
Johnny Cochran.
Try the gloves on.
Jeez.
Yeah, I got a defense. Another question is, why did they have to hold you back?
They didn't have to hold.
That was in a statement.
They didn't hold me back. They kept me from going outside. That's all. I wanted to make sure he got home safe.
Your words, yes, that was in there. Where's my recorder at? No, we don't have one.
All right, we're gonna proceed because we're running low on time. You're excused. Have a seat. Normally, I would now allow both prosecution and defense to make closing arguments. With the amount of time we have, we don't have time for closing arguments. The closing argument is basically their opportunity to sum things up and explain why they believe that the testimony proved the charge or the testimony did not prove the charge. We're going to skip over that. We would then go to voting. And as you saw, we had a charge with 4 specifications. I would have a hand and voice vote for each and every one of those as to whether that happened or not. And at the end, the last one is whether or not that was conduct unbecoming of a member of the American Legion. Because you could say that yes, there was an argument, yes, there was a drink spilled, yes, the man pushed him down, but no, it was not conduct unbecoming, at which point the charge itself is not guilty. You have to have all of the elements proven for the charge to be found guilty. Sir, you've got a question?
Yeah, I got a question. At what point in this, because most posts have cameras, so if there was evidence that was captured on the camera, where would that be in this process?
That would have been introduced by the prosecutor if it helped his case, or the defense if it helped his case.
In the beginning?
Yeah, when they were calling witnesses.
Oh, okay.
They would call a witness who would be the person who took the tape and bring it forward and say, okay, I am the custodian of the tape, I'm the person who manages this, Or you could have a witness who watched the tape and could describe what happened in the tape. So you just call a witness who then presents that particular piece of evidence. Good question?
Paper marking would be the best habit.
Oh yeah, showing the video is absolutely the best. You do want to tell the judge before you're going to introduce that and make sure it's all set up properly and that you have a witness who can authenticate that that is in fact the tape from that time, place, and all of that, so that your evidence is actually authenticated. So again, we would do a vote for. All right, members of the panel, I'm going to do 2 sample votes real quick. And members of the panel, based on the evidence presented to you, did in fact Billy Badass committed battery on Bob Butthead by pushing and shoving Bob Butthead to the floor against his will and without his consent on June 8th, 2024 at Post ABC. All who believe that occurred, raise your hand. All who believe Bob Butthead did not get pushed by Billy Badass.
All that's
All right, well, at that point, we have a negative finding on the actual event that occurred. And because of that, we wouldn't go to sentencing. So I'm going to pretend we got through that and you did in fact shove him, and you all did decide it was conduct of becoming. At that point, we go to sentencing. And in sentencing, we do it in reverse, from most severe to least severe. So, members of this panel, based on your determination that Billy Badass did in fact shove Bob Butthead and that was in fact conduct unbecoming a member of the American Legion, those in favor of expelling Mr. Badass from the American Legion, please signify by saying aye and raising your right hand. Aye. Okay, I got 1, 2, 3, 4, about 10. How many of you believe he should not be expelled from the American Legion, but a lesser punishment is appropriate? Aye. All right. At that point, being expelled is off the table. The next potential punishment is suspension from the American Legion for a period of up to 1 year and the rest of the current year. Sir, you got a question?
Yes, can you remove him from office instead of suspended?
Removal from office because he's an officer is another potential punishment. So before we went through this, I would normally explain that expulsion is one thing, suspension is another, reprimand is another, removal from office is a separate potential punishment, separate from expulsion, suspension, or reprimand. And so we would vote on each and every one of those. Thus the reason I have my report of results of trial, where I can circle and cross things out as I go in. At that point, let's say we came to the conclusion he would be removed from office and reprimanded. That would be the final determination based on your votes, and that would be written into the report of results of trial that then goes forward to department headquarters. I'm sorry we didn't have time to go through all of the votes, but that's how those votes would be done so that we ended up with a final determination by the membership.
Then he can appeal.
And then he has 45 days to file a notice of appeal. We actually had a form out here that you can pick up that shows how that's done, and it's according to the rules governing appeals in the Department of Florida Constitution and bylaws at the very end.
Past incidents get brought up in this?
Past incidents can be brought up if they are charges, or they relevant to the charges, or relevant to, let's say he said, for example, I am a choir boy and a teetotaler. Okay, if he has any past instance where he was banned from the canteen or banned from the post for being intoxicated, that would work. You could bring those up at that point. Those would be rebuttal to his testimony. Or if there was a pattern of misconduct, you could bring that up as well.
Over the severity of the punishment.
And then during sentencing, you could bring it up as far as, okay, we're going into sentencing. I'd like to bring forward a sentencing witness. This isn't the first time. So as we're talking about what kind of sentence to impose, we need to consider the fact that this guy has a history of doing this. This isn't his first rodeo. That would be brought up during sentencing. Yes, sir.
I noticed that there was nothing brought up about the Susie bartender relationship with the commander, the previous times that they got a history between them. And for one, she was lying because she was not even at the post, according to.
No, you're talking about.
Me or Sally? No,
Sally.
you're talking about Sally Busybody.
Sally Busybody was the one that wasn't there.
All right.
The bartender was there.
Yeah, so Sally Busybody has a lot of problems. Sally Busybody wasn't there. Sally Busybody signed the sheet and wasn't a member. There's a lot of Sally Busybody problems. Yes, sir.
So, when you reference past incidents, would those have to be past incidents that went before the board, or would it have to be any documentation that was presented where charges were brought and nothing was acted upon?
Any activity, a witness, a prior action taken, anything that would refute his testimony can be brought forward as a rebuttal.
Even if it's not right?
Even if it's not in writing, you can just bring forward somebody who witnessed a prior incident. Sir?
I know the answer is, but I just want to clarify. And the witnesses do not have to be members of the post,
They could be a member or a guest, anyone who actually observed the conduct. Now, they can't be a juror because jurors have to be postmates. Sir?
Is there a requirement for a maximum or minimum number of jurors?
There is not.
Does that be a form or not?
You do have to have a quorum for the meeting, yes. So I guess you have to have enough people that it would be a quorum at a regular post meeting.
This would all be at a regular post meeting.
And this would be the first order of business at a regularly scheduled post meeting. Sir?
Does the judge have any say in swaying the jury or changing the decision?
Nope. I give you what you're voting on, what the legal standard is, what the charges are, but the judge is not making the decision. The judge is essentially acting. Even if I know it's absolutely flat incorrect, I'm stuck with what the panel members decided.
The judge is an umpire calling balls and strikes.
Yeah.
But in real life, they can, right?
No.
Nope.
Oh, they can't?
No. Juries make decisions. There's a thing called jury nullification where a jury can actually do something that's totally illegal and the judge has to live with it. Sir?
But it would be proper after the prosecution has rested, the defense can make a motion for a directed verdict of acquittal.
They could. If, for example, all of the testimony said the two never touched each other, then he could make a motion for a directed verdict of acquittal because there is no evidence that there was physical contact between the two of them, therefore he couldn't possibly have shoved him. So that can happen. It's very rare. Usually they bring up at least enough evidence to put it in front of the members, and that's the point. Members make decisions.
Who would make that decision? You?
Judge gets to decide that.
Okay.
Is there any way to limit the length of the two sides so that it doesn't become a 2-hour trial or anything like that?
You can, prior to the trial, set forth trial procedures recommended by either defense or prosecution, or the judge can put them forward and say, we're going to allow 5 minutes for opening statements, 5 minutes for closing statements. If they've got a witness list and it's 30 people, we can say, can you pare that down? Some of those are going to be redundant. Defense counsel usually would be the one who bring that up prior to the trial, or we can actually have a pretrial hearing on those matters if we need to. But once we get into trial, witnesses take however long witnesses take, and trials sometimes take a long time. Sir?
What violation constitutes trial?
That is a judgment call for the post, and usually the e-board looks at it. So a lot of times, and this happens at your post, you got some guy who gets into an argument and somebody tells them to fuck off and they tell you to go kiss my ass, and they get into a screaming match and both of them acted like fools. And usually what you do is you have the House committee or somebody get together with them and talk through it and try to work it out. We are not in the business of kicking people out of the Legion. We're not in the business of throwing veterans out of our post. It is only when somebody's conduct becomes so egregious that their conduct is unbecoming a member of the post, it involves dishonesty or stealing money from the post, or there are only 3 things that you can do. Neglect of duty, if they're an officer and they're not doing their job, and usually you do the trial in order to remove them from office, but usually you try to give them a chance to resign first. Say, look, you're just not cutting it. As a service officer, you have done no service for anybody. Would you be willing to resign your position, or do we have to bring you up on trial? Frequently it's handled that way because, again, we're not in the business of throwing people out of the Legion. We're all Legionnaires, we're all veterans, we all care about each other, we should be looking out for each other. And that's incumbent upon you when one of your friends, one of your fellow post members is acting like a fool. Put your arm around him. Walk them outside and let look, Bob, you're acting like an idiot. Why don't you go home, sleep this off? In fact, I'll drive you home. Let's get you home and safe. Let's get you out of this environment. And then maybe tomorrow you get the two of them together and they go, man, I was a fool. I was a fool too, man. Here, let me buy you a beer. You know, whatever it is, try to resolve these things in a friendly, neighborly, veteran to veteran, because we care about each other. That's why we're in the post together. It's only when somebody's conduct becomes particularly egregious and they, in my opinion, and this is my personal opinion, and they have no feeling of having done anything wrong, they have no contrition, they're not willing to try to work it out, they're not willing to do the things necessary. Now, we've had to suspend people from the canteen for a while because it was canteen-related issues, but it wasn't to the point that we wanted to bring them up on a trial and remove them or suspend them from the post. At that point, yeah, so there's house rules. Those are the things you can do in the canteen, and those are, you know, no swearing at the bar was ours for a while. We removed that rule because it was becoming crazy. Somebody said asshole, and all of a sudden people went crazy.
Trial to enforce those house rules.
You do not need a trial to enforce house rules. House rules are enforced by the House Committee and the Executive Board. So you can get a 30-day suspension from the canteen from the House Committee and Executive Board based on your conduct. That does not keep you from coming to the post or going to a meeting or participating in any other events. It's just a suspension from the canteen. Now, if you say, I'm not going to follow the suspension from the canteen, I'm going to do it anyway, now we're going to trial. Sir?
Now, in the event the trial is prolonged, would you be able to do a recess for people, you know, whatever, the restroom, whatever?
Yeah.
And would you sequester the jury first so nobody will get in the bathroom or anything?
No, if the trial is going for too long, and I usually, between prosecution case and defense case, will take a little short recess. Between defense case and sentencing, we take a short recess so that everyone can go to the bathroom,
Get another beer.
No drinking during trial. But as the judge, sometimes I actually have to go to the restroom or take a break, drink some water, or whatever. So we will, you put in periodic breaks, probably once every hour if you're going for a long time. And if the trial's going into extra innings, I have seen them recessed until tomorrow. And we come back. The problem with recessing until tomorrow is now you got to get everybody back. Everybody who's there, so you want to try and do it all in one fell swoop. A trial I did recently, their meeting started at 6 p.m. and their normal meetings take about an hour. Well, we were the first order of business. By 9:30, when we were done with the trial, it's amazing, they wrapped up their meeting in 15 minutes.
If the recess, it's important to notify the jury so that they cannot discuss the case.
Yeah, when you're having a recess, you do ask the jurors. Yeah. While you're taking your recess, please go to the restroom, get a drink, whatever, but please do not discuss the case any further until we're back in the room. Sir, you had a question?
Yes, counsel for the defense. Can it be, say, an auxiliary member from another country?
It can be a licensed attorney and any member of the American Legion. So not an auxiliary member. Question back there.
In your time in the Legion, have you ever seen anyone have a vote of no confidence?
I've never heard of it in the Legion.
So unbecoming of an officer's title within the Legion.
So conduct unbecoming of an officer or neglect of duty, normally if it's an officer and it has to do with their performance of their duties, it would be under neglect of duty. And I have seen that one. Normally, it doesn't get to trial because the executive board takes that officer aside and says, look, you're not cutting it. Why don't you resign? We don't want to do a trial. And if most of the time they're like, I'm a volunteer, I'm doing this for the good of the Legion. If you don't want me, I'm out. And they walk.
So the secondary question is that if your E-board doesn't see it and your general membership sees it, how does the general membership get involved with the E-board and have that interaction to talk about that situation?
So at least in our post, we have a complaint box, and all complaints must be signed by a Legionnaire, dated, and describe the situation. And those are read at every E-board meeting by the House Committee. And so we have them at every E-board meeting, and then some of them are referred back to the House Committee for resolution. Some of them we say, okay, we need to have a conversation. Some of them the House Committee's already reviewed and says, we recommend that this person be suspended from the canteen. And some of them become charges that are then reformatted into a proper charge, brought to the commander then convenes the court, and we go forward.
So can a House committee be consistent, House committee can consist of both E-board members and general membership as well, right?
Whatever your bylaws.
Whatever your bylaws say as to who your House Committee is.
And, you know, your E-board are your representatives. There's nothing wrong with going to an E-board member and saying, hey, look, I don't know if you're aware of this issue or problem or not, but this is taking place.
Thank you, sir.
Prior to the charges being officially filed, that member could transfer out of the post, and would that squash everything because he's gone?
If the member transfers before charges are filed, then the member has transferred and he's somebody else's problem. Once charges are filed, the member cannot transfer out and lose the charge. In fact, because that would be, if the post where they transferred from finds out that they transferred, they can contact the post where the person transferred to and say he had charges pending and therefore cannot be accepted as a member of your post. So once charges are filed, you can.
Charges filed meaning the person was served.
The person was served with charges, yes.
Okay.
Question, yes.
Yeah, you said no drinking when they went on recess. What about the hour and a half before the meeting that they're all sitting there getting drunk at the bar? Is that legal?
My preference personally is that they not be drinking before the trial, but if people were having a few drinks before the trial, the prosecution or defense could challenge them for cause due to intoxication in that they would be unable to properly hear and impartially try the case. So if they've had one drink, hey, you know what? They've had one drink. No big deal. But if somebody is intoxicated and is unable to perform the duties of a juror, it is up to the prosecution and defense to bring that to the judge and challenge that juror because they're intoxicated. And obviously you don't want, and if everybody in the room is intoxicated as a judge, or about half the room's intoxicated, I might say, how many of you have had more than 3 drinks today? Congratulations, you're out of here. Or 3 drinks in the last hour, or whatever. You know, a reasonable determination is to, but if somebody's falling down drunk, I expect your prosecution or defense to point that out. As a judge, again, I'm here to call balls and strikes. If I'm doing things sua sponte as a judge, I'm now taking risk. Judges are risk averse. Any judges in the room?
This is not a formal process like you would see if you went downtown to the courthouse. It's an administrative process. It's not informal, but it's certainly less formal. And basically what we're doing is giving due process, giving the person a chance to come in and have the Legion present evidence against them and have them give them a chance to rebut it. In both phases of the trial, if the person's found guilty, then he gets a chance to rebut whatever he or she thinks about the sentencing. So it's basically just an opportunity for each person to air their grievances and the decision gets made.
Good flag.
Primarily, you're looking for notice, properly formatted, properly presented, as far as the charges and serving on the charges. And then the second half, opportunity to be heard. An opportunity to hear the evidence against them, to present evidence on their behalf, and then to have the members of their post make the determination as to guilt or innocence and as to what appropriate punishment would be should they be found guilty. That's what we're looking for. And there's only 4 legitimate charges. If those words don't appear on your charge sheet, it's not a charge. Make sure you've given proper notice, given proper opportunity to respond, and you do it in a somewhat formal setting for 2 reasons. 1, to give the post confidence that the evidence was heard properly. 2, to give the defense confidence that they were heard. They may not have been listened to, but they were at least heard. They may not have been agreed with, but they did at least have the opportunity to tell their friends what happened so their friends can make a good decision. And again, that's my fundamental thing in this is, at the point we're at trial, we failed. Okay? We have failed. We are now talking about suspending or removing a member of our post from either their office or their membership in the American Legion. Not just the post, the entire Legion. So if you're doing something like that, that means it's gotten so serious that no one could talk this person down, or no one could intervene when the situation started. Once you have fists being thrown, at that point somebody's probably going to trial, or they're going to be transferring out or something. Because you cannot have that level of misconduct occurring in your post and expect other people to want to come to the post. If every time I come to the post I'm breaking up fist fights, you know what I'm not doing? I'm not going to the post anymore.
Not coming back.
If every time I go to the post, people are screaming and yelling and hollering at each other and having knockdown dragouts, I got enough stress in my life. I'm going somewhere else. And you cannot allow one bad actor or 2 bad actors to destroy your post. At the same time, if you've got a bad actor and it's just they need some friendly counsel, be that friend. That's part of being the one too. It's not just be the one to stop people from committing suicide, it's be the one to stop people from being jackasses. I'm sorry.
And the follow-up to that is, if you actually, in Curtis' example, if you actually have somebody exchanging blows, it might be appropriate to make a call to your local law enforcement. Okay, we can keep stuff in the Legion that belongs in the Legion. There's some stuff that just is outside of the Legion and needs to go to the real courthouse. And that's always an option.
That also goes for people who steal large sums of money from the store. There's a certain point where, okay, yeah, he took $5 out of the tip jar. We need to deal with that. Oh, he stole $10,000 from the Children and Youth Program. The district attorney's going to hear about that one. We're not going to do that as a post-trial. We might do it as a post-trial after the criminal trial. But we're going to turn that one over to law enforcement because we want A, our money back, and B, that person has conducted crimes of dishonesty against the post, to say the least. All right, we are way over time, and I do apologize for that. Any questions? Anything else? If you have questions specific to your post, or questions about this, questions about anything else, Dave and I are around all weekend. Please don't hesitate. Thank you all.